Namaskaram. Hello and welcome, hardworking individuals. In today's class, we are going to study about the Representation of People Act 1951. But before we begin, do you know who introduced this act in Parliament in 1951 and what does it talks about on the rising expenditure of the politicians that they expense while contesting elections, and what does it talks about the criminal politicians, how is it making things fair, and what are the provisions involved in it, and do you know this were just finalized before the first general elections that held in India in 1951-52. So there are questions and there are answers. What are we going to see in today's class? If you see, we'll be seeing the key provisions of the Representation of People Act 1951, the landmark Supreme Court and the High Court judgments. We'll also see the recent developments and the amendments that have taken place. Along with that, the key challenges in the implementations and some questions for the UPSC prelims as well as for the mains. For all those things, let's get started the class. And if you want the PDF of this classes for free, you can join our Telegram channel, official Telegram channel, and there you'll get it for free. Now, the overview. The Representation of the People Act 1951, it's a fundamental law that governs conducts of elections in India. So every election that's conducted, this comes under the RPA, that's the Representation of People Act 1951. It complements provisions of the Constitution, especially Article 324 to 329. So these articles lay down the framework for the electoral system in India. It's part 15 of the Constitution. Now, what are the objectives? To provide legal framework for conducting elections to Parliament and state legislature, to set qualification and disqualification for candidates, to regulate political parties, their registration and the conduct, and also to ensure transparency, fairness and integrity in the electoral processes. So nowadays you see after every election Election Commission of India is in news, whether it is for the ballots or it is for the SIR that's being done recently. So it is really very important to know the base, how actually the electoral system works in India. This act has been amended several times to adapt the changing political and the social landscapes. Okay, what are the key provisions of RPA? Let's start with the point number 1, that's conduct of elections. That is a part 5, sections 30 to 58 talks about it. So what's the Election Commission's role? We are going to see Article 324 and the section 29A. Election Commission of India holds authority to supervise, direct and control elections, including the delimitation of constituencies, preparation of electoral rolls as well as scheduling of elections. So delimitation basically means how many seats will be there, that should be increased or decreased, that is decided by them. And also the electoral rolls, as I have already said you that recently it's been in the news. We are going to do a separate video for that. If you want it, you can comment and let us know. And the scheduling of elections, so when the elections will take place, this also comes under the provisions of the conduct of elections. So now nomination process is something candidates must submit nomination papers within the prescribed timelines, and also the returning officer scrutinizes the application for the eligibility, whether they are properly eligible for that or not. What are the eligibility criteria? We will see in coming up slides. Election process, that's including polling, counting of votes and declaration of results, use of electronic voting machine and voter variable paper audit trail has been integrated to ensure the transparency. So this is what I was saying you, that the EVMs are under the scanner or the question if you're following the news. The second point that we are going to talk about the Representation of People Act, that's a qualification for membership, that comes under the section 3 to 6. The Lok Sabha or the House of the People it has the criteria that the individual must be an Indian citizen, minimum age should be 25 and must be a registered voter in any parliamentary constituency. When it comes to the Rajya Sabha, the minimum age is 30 years. must be an elected in a parliamentary constituency, does not require residency in state from which contesting after the 2003 amendment. And also the state legislature, similar qualification apply with appropriate age requirements for the legislative assemblies and the councils. What about the disqualification for membership? So if you see, it comes under section 8 and the 10A. Disqualification on conviction, that's section 8. Section 8(1) talks about conviction for serious offences like terrorism, rape, corruption, dowry related crimes, human trafficking, etc. lead to immediate disqualification. Section 8(2) conviction for offences under laws like the Prevention of Corruption Act, Narcotic Drugs Act. Section 8(3) disqualification if sentenced to imprisonment for 2 years or more. And key point is Lily Thomas versus Union of India judgment invalidated section 8(4), ensuring immediate disqualification without waiting to appear for the to appeal outcomes. Okay, disqualification for corrupt practices, that's section 9. It talks about involvement in bribery, undue influence, booth capturing, as well as the manipulation of voters. And then we see the disqualification for office of profit, that's section 10, holding an office that offers monetary benefits under government authority. Exceptions apply to certain designated offices. And disqualification for election expenditure violation, that's section 10A, failure to submit accurate election expenses reports within the prescribed timelines. What about the number D, that's corrupt practices and electoral offences, that comes under the section 123, 125 to 136. The corrupt practices section 123 talks about the bribery, offering money, gifts or favors to influence voters. It also talks about the undue influence, that is coercing or intimidating the voters. You also see the appeals on religious or the caste grounds, banned to ensure secular electoral practices. And also booth capturing, seizing polling station by force or intimidation. Nowadays you might see it happening very less, but in the earlier times we saw that this was quite common practices in places like UP, Bihar, West Bengal and other places. Electoral offences, promoting enmity based on religion, caste, languages. This is also something is considered as an offence. A false statement, you can't mislead, you can't declare things regarding candidates' background. And also illegal hiring of vehicle for transporting voters without proper declaration. This is also considered illegal. Now what about the next, the election expenses? Now this is something that should be kept in the mind, because nowadays what we are seeing that with time the expenses in the elections is becoming so very much that if a common man wants to contest the elections, it's not possible for him to expand that much. Okay, so if he can't expense that much, how is he going to fight the election? So that what is being done, there is this mandatory accounting. Candidate must maintain detailed records of all expenses incurred during the campaign. Then the spending limits, ECI prescribes expenditure limits varying by state and constituency size. Like recent limits for Lok Sabha is somewhere around 70 to 95 lakh, and for assembly it is 28 to 40 lakh. What about the non-compliance? Failure to submit or misreporting expenses can lead to disqualification under the section 10A. Okay. Now next, the election petitions. What about this? Filing of petition, filed in High Court within 45 days of election result declaration, then it can be entertained, and grounds include corrupt practices, improper acceptance, rejection of nomination and booth capturing. If any of these things have happened, you can go and file the petition. Now what about the appeals? Decision can be appealed to the Supreme Court as well. Regulation of political parties, that's part 4A, section 29A. It talks about registration with the Election Commission of India. Political parties must register with ECI under the section 29A. Condition for recognition based on vote share, number of seats won, etc. And the financial transparency. Parties must submit annual financial report detailing donation and the expenditure that they have got. Now the landmark Supreme Court and the High Court judgment that have impacted this electoral processes, let's see about them. So number one is the Lily Thomas versus the Union of India case of 2013. What was the verdict? Supreme Court held that any MP, MLA, MLC convicted of an offence and sentenced to 2 years or more shall be disqualified immediately without benefit of appeal. What was the impact? Overturned section 8(4) subsection, which previously allowed convicted lawmakers to continue in office while appealing. Okay, now second is the Union of India versus Association for Democratic Reforms 2002. The verdict says that the Supreme Court mandated that candidates must disclose their criminal records, assets, liabilities and educational qualification when filing nominations. What was the impact? Enhanced transparency and voter awareness, laying groundwork for voters' right to know as a fundamental right under Article 19(1)(a). Now, Public Interest Foundation versus Union of India of 2018. This case, the verdict was that Supreme Court declined to bar individuals with criminal charges from contesting elections, but directed political parties to publicize the criminal background of candidates. What was the impact? It led to ECI guidelines requiring candidate and parties to publish details of criminal cases in newspapers and on social media. Next is the Krishna Kumar Singh versus State of Bihar 2017. Verdict was Supreme Court ruled on the limitation of ordinances issued without legislative approval, impacting election related ordinances issued by states. What was the impact? Strengthened principle that the electoral laws must undergo proper legislative scrutiny. It should not be dependent on the ordinances itself. There are some others also that you should know about, like the Kuldeep Nayyar versus the Union of India 2006, upheld constitutional validity of open ballot voting in Rajya Sabha elections aimed at reducing cross voting and corruption. Then you have the Rajbala versus the State of Haryana 2015. The verdict, Supreme Court upheld Haryana's law imposing educational qualification as a criterion to contest the panchayat elections. So, but sometimes there is a joke also that to become an IAS, even to become an inspector, even to get a lower rank government job, group D job also, you need educational qualification. But to become a minister or a good politician or to get elected as an MP or MLA, you don't need any educational qualification. So this was done in Haryana for the panchayat elections, and it raised debates on whether educational qualification should be mandatory for the electoral candidates at all levels. Then there was this Navjot Singh Sidhu versus State of Punjab 2007. It addressed disqualification under section 8 following criminal conviction, clarifying that such disqualification applies immediately upon conviction. Then you also have the Anugrah Narayan Singh versus the Harshvardhan Vajpayee. There's the background of the case is challenges against 2017 Allahabad High Court ruling and allegations of corrupt practices under section 123(2), under influence, and section 123(4), false statement. Accused MLA's alleged offence, non-disclosure of liabilities and false information about educational qualifications. Also, the Allahabad High Court decision about dismissed the petition, stating that inaccuracies in affidavit were not substantial enough to influence election result or voters' decisions, and defects were not deemed to be significant character to be classified as the corrupt practices. What about the recent developments and the amendments that have taken place? So the electoral bond scheme challenged in Supreme Court 2024, something that was quite very much in the news for the present government, that's Mr. Modi's Prime Ministership government. Controversy was allegation of opacity in political funding by anonymous donors. So who is donating, what amount is being donated, to which party is being donated that much amount, that should be for the public to see, and the status matter is sub judice before the Supreme Court with significant implications for transparency in campaign financing. Next, we also see the Election Laws Amendment Act 2021, where we see allows linking of voter ID with Aadhaar card to prevent duplicate voter entries, and also concern raises issues around privacy and potential for voters disfranchisement. Okay, so what does this means? This means that in a way, when the voter card is linked with the Aadhaar card, in that way you can prevent this duplicate voters, in a way that this is being a problem. Okay, in a few of the states we see that there are duplicate voters. There are voters who are not of Indian origin, but they have somehow and others got this voter cards. So this disenfranchisement is something that should be taken care. Okay, now the criminalization of politics or the ongoing issue. Despite the Supreme Court directives, significant percentage of MPs and MLAs have pending criminal cases. 2020 Election Commissions of India's guidelines, if you see, mandate political parties to explain why candidates with criminal backgrounds were chosen over clean candidates. Okay, now there is this Supreme Court ruling of 2023. The context is Supreme Court directed political parties to publicly disclose criminal antecedents of candidates within 48 hours of selection. And what was the impact? Aim to curb increasing trend of criminalization in politics. We have discussed at the very beginning that the Election Commission of India is working to make the electoral system free of these criminals which come in the form of politicians. But to be very frank, still it is said that 50%, more than 50% of the elected members are coming from the criminal backgrounds. Now, one nation, one election proposal is something that is what this present government is working for. The debate is to propose to synchronize Lok Sabha and state assembly elections to reduce the cost and the election fatigue, and it requires amendments to the Representation of People Act 1951 and possibly into the constitution also. Some of these amendments are required. What about the decriminalization of defamation 2023 petitions pending? So cases challenging the criminal defamation laws which have implications for the candidates disqualified under section 8 for the defamation related convictions. There was this High Court judgment. Kerala High Court 2022 disqualified an MLA for paid news violation, citing it as a corrupt practice under section 123(4). And also the Madras High Court 2023 struck down provisions of a state law that conflicted with the RPA on local body elections, reinforcing the supremacy of RPA. Now there are some key challenges in the implementation. What it is: number one, the criminalization of politics. Like that, despite judicial intervention, over 43% of MPs have pending criminal cases. Now, electoral reforms needed. Issues like inner party democracy, state funding of elections, and regulation of digital campaign are not fully addressed. Misuse of disqualification powers. Allegation that disqualification provisions are sometimes used to settle political scores, and lack of uniformity in High Court rulings. Different interpretations in election petition cases create the inconsistencies. So these are some of the challenges that are coming in the implementations. Now we are going to see some of the prelims questions. So if you see, which of the following provisions are covered under the Representation of the People Act 1951? Allocation of seat in Lok Sabha, disqualification for membership of the Lok Sabha, delimitation of the constituency, and also the oath of members of the parliament. So in the comment section, please go and tell us what is the correct answer to this question. Next is the question where it is about the provisions of the Representation of People Act 1951. Again, there is statement like supervise the preparation of electoral rolls, delimit the constituencies, decide on disputes arising out of election to the office of president, and also de-recognize the political parties. Again, we have already gone through all these points, so please go in the comment section and tell us what is the right answer here. There are some mains practice questions as well that you can see. Discuss the role of the Election Commission of India in ensuring the integrity of elections under the Representation of People Act 1951, and critically analyze the legal framework provided by the Representation of People Act 1951 in ensuring the conduct of free and fair elections in India. So guys, with that we have come to the end of this class. I said you that, do you know who introduced the Representation of People Act 1951? Well, it was the then law minister. No, that was not the first. Elections have not were not held by then. It was the provisional government, and the then law minister at that time was Dr. B.R. Ambedkar. So it was Dr. B.R. Ambedkar who introduced the Representation of People Act 1951 in the parliament, and it is our duty now to take care of this electoral system, because if the electoral system itself is corrupt or it's lacking, we can't think of getting the results foolproof. So with that, if you have not subscribed us yet, you should subscribe so that we keep informing you, and we'll meet again. Till then, keep working hard for success. Today or tomorrow you will be successful. Namaskar.